Hi, Alan Wood again with the Alan Wood team, and we're here with Jerry Vasile, our local attorney, one of our local attorneys as well. Just talking about the next section of 2. 2 it talks about, last session we talked about deposit a little bit. This next part talks about the deposit, like who holds it and where it's being held. Typically on our contracts, it's usually held by the listing office at their bank of choice. So example, our listing office, we have KeyBank as our bank. And so if a buyer gave a deposit, it would get turned into our office and it would get deposited into our escrow account at KeyBank. So Jerry, give me a little bit of info about the deposit, like where does it go or what happens with it if there's a dispute in the contract between the buyer and seller.
Okay, so that deposit, as Alan mentioned, is going to be held in trust or in the listing broker's, typically the listing broker's trust account. And if the seller breaches the contract, then simply the buyer is going to get that deposit back. If the seller alleges that the buyer breached the contract, then they would be entitled to the deposit in the form of damages. The important thing to note is that there has to be a meeting of the minds between the buyer and the seller as to how that deposit is going to be handled. The listing realtor who's holding the deposit can't unilaterally decide who's right or wrong. Neither can the attorney for the seller or the attorney for the buyer. So it's going to sit in trust. If there is no mutual meeting of the minds between the buyer and the seller, then it will stay in trust until a court of competent jurisdiction makes a ruling on it, which essentially means one party will have to sue the other for the deposit.
And we've had deposits sitting in our account for a long time, but typically it gets resolved between the buyer's attorney and the seller's attorney. But we cannot just release it, because if a buyer says, oh, the seller breached the contract, we want the deposit, or the seller says the buyer breached it, we want the deposit, we cannot release it unless both of them have agreed and signed on a release that X party gets it or the other party gets it, or it's split or whatever.
Correct.
And if not, unfortunately, it sits in our account until it gets resolved through litigation or they both agree to terms.
Exactly.
And that talks about, then it goes on in section 2 to say a little bit more about seller concessions, and what it just says there is the lender approved prepaids and closing costs cannot be exceeded. So if the seller concession is $5,000 and the lender approved closing costs and prepaids are $4,500, that extra $500, the buyer would not get that. It cannot exceed what the lender approved costs are in prepaids. So it's a little bit in depth there, but if you have any questions on that, you can feel free to give me a call and I'd be happy to explain it in better detail there for you. Thanks everyone for joining Jerry and I today. And that is part of section 2 again. Have a great day.